Hello, this is a talk about bringing a claim for judicial review in which I'm going to cover case management in the administrative court. My name's Declan O'Dempsey. I'm a barrister at Cloisters Chambers. In the administrative court, like in the other civil courts in England and Wales, the procedures are governed by the civil procedure rules, and those rules have got an overriding objective, their main purpose, which is set out in Rule 1.1. All cases are to be dealt with justly and at a proportionate cost. This includes ensuring that the parties are on an equal footing. So if you're representing yourself, the court tries to make sure that you're not disadvantaged by that fact. It includes saving expense. So when considering whether or not to grant an application, the court will consider whether or not it results in wasted expense or whether there is a way of doing what needs to be done while saving expense. It includes dealing with an application in ways which are proportionate to the amount of money involved, to the importance of the case, to the complexity of the issues, and to the financial position of each party. It includes ensuring that the case is dealt with expeditiously and fairly. But it also includes allocating to the case an appropriate share of the court's resources while taking account of the need to allot resources to other cases. Case management includes ensuring compliance with the rules, with practice directions, and with the court's orders, of course. And this is an increasingly important aspect of the court's concerns. The court will actively manage cases. Now, this means that it will encourage the parties to cooperate with each other in the conduct of the proceedings. So whenever you're considering a stage in the proceedings, try to see whether you can cooperate with the other party to reach a position which is agreed between you both and which will get the case to court in a fit state for the judge to consider the issues properly. So that involves the identification of issues, and active case management involves the court identifying the issues at an early stage. So they'll be encouraging you to identify the issues early on. It also means deciding promptly which issues need full investigation and trial in most civil cases, and accordingly disposing summarily of others. Now, in judicial review terms, that means that you may get permission to proceed with some of your grounds of challenge, but not all of them. And the court will be considering whether the issues you're raising in the particular ground you're arguing actually does need a full trial, or whether it should be disposed of summarily, i.e. there and then. Active case management also involves deciding the order in which issues are going to be resolved. So there may be a logical order to the issues in your case. Try and think about what that logical order is. If you succeed on one point, do you need to go on to consider the next point, and so forth. Active case management will also involve encouraging you and the defendant to use an alternative dispute resolution procedure if the court considers that this is appropriate, and the court may well facilitate the use of such procedure. So you may get the judge suggesting that the parties talk to one another, for example, then and there at the hearing, to see if they can resolve the dispute, or suggesting that in an adjournment they should talk to one another and see whether there is common ground that can be reached, either on the whole case, so that the case is settled, or so that particular issues do not need to be addressed by the court. So in other words, active case management involves helping the parties to settle the whole or part of the case. It could involve fixing timetables for what's going to happen during the case. So the judge may say to you, well, you're going to get so many minutes to argue your case, and the defendants are going to get so many other minutes to argue their side of the case. The judge is entitled to control the progress of the case by other means, not simply timetabling. Active case management involves considering whether the likely benefits of taking a particular step in the case justify the cost of taking it, and that's something that you'll need to address if you're asking the court to grant you an interim application which may cost the parties money. Is the step worth the cost of taking it? The court will actively manage the case to try and deal with as many aspects of the case as it can on the same occasion, and it will try and deal with matters in the case without the parties needing to attend the court. So it may be that you can get quite a lot of the interim stages of your case dealt with without the need to attend court. The court is also entitled to use technology, so to make telephone calls to try and manage the case. And it's also entitled, whilst it's actively managing the case, to give directions to ensure that the trial of a case proceeds quickly and efficiently. And in the context of the administrative court, that means giving directions to try and get the case to a substantive hearing as quickly and efficiently as possible. The parties are required to help the court to further the overriding objective. This is a very important point, hence the slide on its own, and you should take this very seriously. It isn't simply something that you can use to attack the other side's conduct, but you must be very conscious of the fact that you, as a claimant, are required to help the court to further the overriding objective. This is an argument that you can use towards a defendant in correspondence. For example, you make the suggestion that a certain course of conduct should take place, and then you show how it would further the overriding objective which we've just been looking at. Within that idea of the overriding objective and furthering that overriding objective, the parties therefore have certain duties. Both parties should make efforts to settle the claim without requiring the intervention of the court. So by the time you've entered on litigation, you may well have tried to talk to the public body and written to them about ways in which they could concede the decision was not lawful and that another decision should be reached. But it's always worth keeping the door open for settlement negotiations during the course of the hearing. So write to them again. For example, when you've been granted permission, it may be that that's a good opportunity for the defendant to be reviewing their position, and it may be that if you make certain concessions and they make certain concessions, then the case can be disposed of without the need to go to court. This is what's meant by saying that there's a continuing duty on the parties. The parties have got this duty to further the overriding objective, and they should continue to evaluate their case throughout its progress. And the guidance from the administrative court on bringing a claim for judicial review suggests that this should happen, this evaluation should happen, after any indication as to the strength of the case from the court. So, for example, you've been for a permission hearing, and some of your grounds have got through, but not all of them. So you may consider, first of all, the strengths of the grounds that did get through, how strong are your arguments there, and it's also going to be a factor in deciding whether or not you try and renew your application. The parties should also consider using alternative dispute resolution, for example mediation. This will enable you to explore settlement of the case, and if it doesn't do that, it may give you the opportunity to narrow the issues in the case with the defendant. In judicial review cases, there are normally no case management hearings. This is different to the way a case would normally progress through the other civil courts. It is a general rule, however. You can apply for interim orders, or the court may make case management orders, and that may involve having a hearing. More often than not, however, in the admin courts, it'll be done without a hearing. A consequence of not having case management hearings in general is that the first time the parties appear in court before a judge is actually the final hearing of the claim in a lot of cases. So the guide stresses that the parties have got a duty to ensure that they maintain between each other effective, constructive and regular communication, and they must also maintain that kind of communication with the administrative court office. The guidance stresses something that we talked about in the first talk in this series, which is the duty of candour. Remember that the procedural rules are there to be complied with. There'll be some occasions on which you cannot comply. And I want to say something about what you should do if it becomes obvious that you're not going to be able to comply with the requirement of the procedural rules or with an order. The first position has to be that you must comply with the procedure in the civil procedure rules and practice directions and the orders of the court. Now, these include orders given by an administrative court office lawyer, and we'll talk about that in a minute. But if you know that you're not going to be able to comply with a requirement of the procedure, you should inform the administrative court office and the other parties as soon as possible. And you should make an interim application to extend the time limit for doing whatever it is you're not going to be able to do within the existing time limit as soon as possible. When you realise that you're going to have to make this type of interim application, and I suggest that you should always make the application before the time limit for doing what you're supposed to be doing has expired, but when you realise that an interim application is needed, you should inform the other parties and then make the application as quickly as possible. This is because delay in making the application or a failure to put the court office or other parties on notice, especially where what's needed is urgent consideration, is going to be a factor which the court will take into account and which will weigh against the granting of the order.